This is not just another courtroom hearing. This is a ticking time bomb of second chances pushed to the absolute limit. A defendant already convicted of family violence assault, already given the gift of probation instead of prison, is now back in front of the judge. Again, multiple violations. Missed rehabilitation programs. Even drugs in his system. The court is about to decide. Is this someone worth rehabilitating or someone who has run out of chances? And here's the twist. This decision doesn't just affect him, it sets a precedent for everyone watching. So ask yourself right now, how many chances should someone really get before enough is enough?
In summary, this motion states that on August 17th, 2021, in this court, you were sentenced to 10 years in prison. That was suspended. You were placed on regular probation. You were convicted and placed on regular probation for 10 years for the third-degree felony of assault, family violence. And it goes on that this indictment that you pleaded guilty to and were convicted of goes on to state that you had previously been convicted of a family violence assault before you picked up this other part of the allegation in the indictment. So that was the second offense of assault on a family member. And is all of that true that you were convicted that day with a third-degree felony? Correct?
Yes, sir.
Oh, yeah, speak out.
Speak up. Yes, sir.
All right. He had earlier entered pleas of true to allegations 3 and 4, being in another county and failing to enter and successfully complete the battering intervention program. He entered pleas of true to that back in August of last year. Yes?
Sure.
Okay. And 8, you failed to attend. Once again, this is the second notice. You failed to attend the Batterers Intervention Prevention Program, BIPP is what it's referred to as directed by the court, which is inherently important in this crime that you were convicted of. And that was a violation of a special amendment to your probation filed on August 6th of last year, after we went through the first hearing where you admitted not doing it. So, did you fail to attend as required the Batterers Intervention Program?
True.
What happened there that you are aware of? I mean, we called your hand on it in August about attending, how important it was for the BIP program to be followed. Why didn't you?
I do the bill. Then talking about the program I'm in now.
Yes.
You
You admitted, no, wait, you submitted that you failed to attend. Has he attended or not?
No.
Every week?
I don't know about March, but February.
No. Since August of last year when we made a big deal.
He got in the program, because he was in Harris County custody until I think October. And then when he got out, he enrolled in the program. And
That
December
doesn't
was
do it for
going.
me. You can.
Let's pause right here, because this moment is critical. The Battering Intervention Program, BIP, isn't just a random requirement. It's a court-ordered rehabilitation tool specifically designed to address violent behavior patterns. When someone skips sessions, logs out early, or makes excuses like connection issues. The court doesn't see inconvenience, it sees non-compliance and lack of accountability. And legally speaking, failing to complete BIP is a serious probation violation because it directly relates to the original offense. So now the question becomes, is this someone trying and failing, or someone simply not trying at all? What do you think should effort matter more than results in a case like this?
Enroll all day long. You got to go through it and complete the program as directed.
Right. I told you I can do the 13 week.
He's supposed to do it weekly.
Yes,
Since August, how many weeks has he failed to attend?
it's 15 sessions, but I don't know how many he has actually attended.
Well, how do you?
We also, like, I have one report from January
How much time
2026
credited all for all this?
where he was attending, but he logged out early, and he doesn't get credit if he logs out early with no explanation.
But can I speak?
Hold on, let me read this. Okay. On February 10th, you said you reported you weren't feeling well. and on February 17th, you were having connection issues. So, okay, now, so what we've got today is this is the fourth violation he's admitted to. And one of these is a crime, cocaine in your system. A second allegation of not attending the program as required. You pleaded true to that earlier in another motion to revoke probation. So what we do up here is we set a standard. What's good for...
This is where things get intense. The judge isn't just looking at one mistake, he's looking at a pattern. For violations, multiple chances. And now he's raising a bigger issue: fairness in the justice system. Because if one person is allowed to repeatedly violate probation without consequences, what message does that send to everyone else? Courts operate on consistency. That's how trust in the system is maintained. And notice how the judge frames it. He's not just judging this defendant, he's thinking about every future case that will stand in this courtroom. So let me ask you, should judges prioritize individual circumstances or protect the integrity of the system as a whole?
One is good for everybody. That's fair. We're trying to do fairness. How many intentional violations do you get before it's revoked? And everybody's going to listen, because the next person that's going to come up on a motion to revoke is going to go, I'd like the Floyd Brooks rule, please. I'd like to violate 4 times, but stay on probation because you did it to him. Are you going to be fair, judge, or not? What do I say to that?
Judge.
Oh, really, the cocaine? Where did you get the cocaine from?
From a friend.
Well, who? See, you aren't going to give up your source.
Yeah.
And that's the way it is.
Thank you.
That's the way it is.
Thank you.
No, of course, you think I don't see this after 45 years in this business?
Oh, well.
Come on. No, I'm not going to beg. You promised that you would follow the rules when we placed you on probation. This is the 3rd time you've been up here. Originally, the first motion, and now the second. How many chances do you get? Everybody's going to watch and go, I want the chances. I want to be able to foul up 3 separate times, knowing I made a promise not to do it at the first place. You're running out of chances with me. What do y'all say?
Your Honor, I'll just, if I might,
How much time?
require the probation officer to be willing to work with him, what she thinks of the future.
I thought they were willing to work with him when we placed him on probation 5 years ago.
Well,
4.5 years ago.
I think
It's his problem now. We've had to deal with it, and this is way too many times for crimes, for drugs, for not taking care of the whole source of the problem, the battering issues. You made bad choices. You don't even attend that regularly.
Your Honor, if I might, I think that the ultimate goal of probation would be to rehabilitate someone and be able to restore them to society in a condition where they're able to participate as a full legal law-abiding citizen productively. And I know that
Wait, what's law-abiding about buying cocaine or purchasing drugs? Cocaine, it's a second-degree felony.
It's a continuing struggle with Mr. Brooks, but obviously there may be some positive things too that he's made progress with that would militate in favor of at least giving one more opportunity to do this probation. He has indicated that he's employed.
Now here comes the defense strategy: rehabilitation over punishment. They're arguing that probation exists to help individuals reintegrate into society, pointing out employment and potential progress. And to be fair, that's a valid legal argument. Courts often balance public safety versus second chances. But here's the problem: progress only matters if it's consistent. Employment alone doesn't erase drug use, missed programs, or repeated violations. The judge is clearly weighing this: is this genuine progress or selective compliance? So think about it. If someone improves in one area but keeps failing in others, should that be enough to avoid prison?
That's a huge part of probation.
Yes.
And it doesn't appear to be
This is his third opportunity.
With
He
him,
was placed on probation the first time that we had a motion to revoke probation that I did it again. And then here we are.
well, it seems to be reporting is required, Your Honor, is working. That's probably, I would say maybe half of what he needs to do. The other half, he's had.
He's committed crimes.
I don't have an explanation or excuse.
I know, it was, you're in a hard spot. We set a standard up here. The victim in this case, do you still,
No, it does.
you have no contact with that person?
I'm not doing that for now.
Sir,
I'm trying to go.
He's asking about contact.
Yeah.
the person who was the victim in the first place, that's, I mean, you're not still married to that person or,
No.
okay. Well, sometimes that happens and that's a problem because I want a family unit. And sometimes people make mistakes and we can work with keeping them together if that's in the best interest of everybody and we're sure that a problem's not going to happen. But that's not an issue here. I don't like breaking up families, but these are serious. The family unit is an important part of this of America.
If the court's inclined to look for something at the lower and applicable statutory range.
It states
Since he's not been to prison before, we'd recommend 5 years.
what you hear what we're saying. What do you say? You have a chance to be heard. You have 180 days credit. That's a half a year, but the state's asking for 5 years.
What do you have to say? Tell me, James.
It's a crime of violence. I mean, people don't find that amusing.
I need more chances to be out in this world. I can work. I'm gonna change. Michael get in no more trouble.
You made that.
No more trouble. Real nose. Real pay everything. Please. I'll be real. I'm gonna do my classes on time. I just want to work.
It's just,
That's it.
That's fine. You made a deal with me when we put you on probation. I've received a copy of this order you signed, that you signed. I agree to follow all conditions imposed, and I know this probation can be revoked for any violation. This is the second time since then you've been before me for violations. You broke your promise twice. And these are important things. It's not just, you committed a crime, but the batter's prevention is important to fix the choice you made here on assaulting a family member. This person, the victim in the first place, was that your wife? Yeah. Your wife?
That was my girlfriend.
Okay. That's the wrong way to show affection, for someone you care about. Right. If nothing further, I'm going to find that there is sufficient evidence supporting this first amended motion to revoke probation to grant it by a preponderance of the evidence or greater, as allegations 7 and 8 have been proven true, based upon the defendant's voluntary and knowingly made plea of truth to those allegations. Thus, I find this first amended motion to revoke probation to be granted by preponderance of the evidence or greater. Your probation is hereby revoked, sir, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years, and you will be given credit for time you have served.
In the end, the court made its decision, and it was decisive. After reviewing repeated probation violations, failure to complete mandated programs, and continued criminal behavior, the judge revoked probation and sentenced the defendant to 3 years in prison. Legally, this outcome reflects a key principle. Probation is a privilege, not a right. When conditions are repeatedly broken, the court is justified in enforcing the original consequences. This case highlights the delicate balance between rehabilitation and accountability, and how quickly second chances can run out when commitments aren't honored.